Chapter 21, Suretyship and Guarantee. Section 220. Terms defined and distinguished. Guarantee is an undertaking by one person that another shall perform his contract or fulfill his obligation, and in case he does not do so, the guarantor promises to do it for him. A guarantor of a bill or note is one who engages that the note shall be paid. A contract of suretyship is a contract by which the surety becomes bound as the principal or original debtor is bound. It is a primary obligation, and the creditor is not required to proceed first against the principal before he can recover from the surety. The surety is bound with his principal as an original promisor, that is, he is a debtor from the beginning and must see that the debt is paid, and is held ordinarily to know every default of his principal, and cannot protect himself by the mere indulgence of the creditor, nor by want of notice of the default of the principal, however such indulgence or want of notice may, in fact, injure him. Being bound with the principal, his obligation to pay is equally absolute. On the other hand, the contract of a guarantor is his own separate contract. It is in the nature of a warranty by him that the thing guaranteed to be done by the principal shall be done, and is not merely an engagement jointly with the principal to do the thing. A guarantor, not being a joint contractor with his principal, is not bound to do what the principal has contracted to do, like a surety, but only to answer for the consequences of the default of the principal. The guarantor has to answer for the consequences of his principal's default. A surety is an insurer of the debt. A guarantor is an insurer of the solvency of the debtor. A surety may be sued as promisor, but a guarantor cannot. The surety and the principal, being equally bound, may be joined as defendants in one suit, or the surety may be sued alone, without any effort having been made to recover the debt from the principal, but a guarantor, being bound by a separate contract, must be sued separately. Section 221. Consideration as to guarantees. The general doctrine upon this subject is that a consideration is necessary to support a guarantee. In some instances the consideration of the note or bill is of itself sufficient, while in other cases an independent consideration is required. A guarantee of the payment of a negotiable promissory note, written by a third person upon the note before its delivery, requires no other consideration to support it, and need express none other than the consideration which the note upon its face implies to have passed between the original parties. In such a case the credit is given to both, and not to one alone, although only one may derive any substantial benefit from the transaction. But a guarantee written upon a promissory note, after the note has been delivered and taken effect as a contract, requires a distinct consideration to support it, and if such a guarantee does not express any consideration, it is void. Where the statute of frauds of the state requires the consideration to be expressed in writing, there seems to be an exception to this requirement, as in the case where the guarantee was agreed upon at the time of making the principal contract, and it was merely committed to writing afterwards. If the consideration is a continuous thing, running along at the time both of the principal contract and of the guarantee, it is considered a contemporaneous guarantee and does not require a distinct consideration. Section 222. Guarantee is affected by statute of frauds. Guarantee is an undertaking to answer for the debt or default of another within the meaning of the statute of frauds, and must accordingly be in writing and signed by the party to be bound or by his lawful agent. Since a guarantee is a promise or an undertaking by one person to answer for the debt, default or miscarriage of another person, the question arises as to whether or not a writing setting out the consideration and signed by the person to be charged thereby is necessary. The courts in this country are agreed that the signature of the party to be charged must be obtained, but the decisions are at a variance as to whether the consideration for the guarantee should also be set out in full. If the statute only requires the promise to be in writing, it seems that the consideration need not be in writing. This is established upon the principle that the promise is not the entire agreement and therefore does not include the consideration. In order that the agreement may be controlled by the statute, it must contain a promise to answer for the debt of another both in form and in fact. It has been held that if the transaction be nothing more than an indirect way of guaranteeing the payment of one's transfers to his creditor, such as giving the note of another which is payable to himself with a guarantee that this third person's note will be paid, the guarantee is substantially that the guarantor's original debt will be paid by the collection of this third person's note, and for this reason the guarantee need not be in writing. Section 223. Negotiability of guarantees. Whether a guarantee on a negotiable bill or note is itself negotiable is a question concerning which there is much confusion. It is held by some cases that the guarantee does not fall within the rule of negotiability, and can inure only to the benefit of the person to whom it was given. On the other hand, it is held in some jurisdictions that the guarantee passes with the instrument, and inures to the benefit of the holder. Some of those cases, holding that it passes with the instrument as being negotiable, treat it in the nature of an endorsement, while still others hold that it is not negotiable on the ground that it is a contract of the common law and not of the law merchant, and consequently is incapable of negotiability by any intention of the guarantee. Authorities, however, are not wanting which decline to take this view where the guarantee is by a third person, and not by the holder of the instrument, and, while not readily allowing negotiability to a guarantee, allowing it to the guarantee if the language of the guarantee does not restrain it. The better doctrine seems to be to hold the guarantee as non-negotiable, since it is a common law contract and is not properly considered an endorsement. It may be transferred with the endorsement by assignment, and the assignee can then maintain an action upon the guarantee in his own name under statutes of most of the states. Section 224. Notice to guarantor of default of principal when demand is made. The guarantor's contract is more rigid than that of an endorser, and he is bound to pay the amount upon a presentment made and notice given to him of dishonor, within a reasonable time, and in the event of a failure to make presentment and give notice within such reasonable time, he is not absolutely discharged from all liability, but only to the extent that he may have sustained loss or injury by the delay. The same person may be a guarantor and also an endorser of a note, and in such case the failure to give him due notice of demand and non-payment will discharge him as endorser, but he will still be bound as a guarantor. In case the principal is insolvent at and before maturity of the bill or note, the guarantor is liable, because it is presumed that the guarantor has suffered nothing in that case from the failure to give notice of the default. Section 225. Liability of concealed sureties on accommodation paper. If a person who signs an instrument as an accommodation for another party and writes the word surety after his signature, he must be treated as such by all subsequent holders whether he be the drawer or acceptor of a bill of exchange, the maker of a promissory note or the endorser of either. But in case the instrument does not disclose his real character as a surety, the question then arises, can such a relation be shown and the liability fixed in accordance therewith? The English equitable rule is that the character of a concealed surety who appears on the instrument as a regular acceptor or endorser may be shown by parole evidence as against all parties except a bona fide holder without notice. However, the great weight of judicial opinion denies the admissibility of parole evidence to prove the party's real character where it would materially change the party's liability to the paper, and follows the English common law rule, which permits all subsequent holders to a bill or note to treat all the prior parties according to their ostensible character. But if the concealed surety is a CO maker or drawer, and proof of his character would not reverse the evident intention of the parties as to his relation to the paper, the general trend of judicial opinion in this country is to admit such proof. Section 226. Remedies of guarantors. The remedies which are available to guarantors are of two classes. The first and most common is that by which the guarantor pays the debt and recovers of the principal and all other parties whom the holder may have held liable, but he can only recover a sum equal to the amount he was compelled to pay with interest on the same. The second method which he may pursue is to file a bill in equity, making as parties thereto the creditor and the principal parties, to enjoin proceedings against himself until the resources of the principal have first been exhausted. The creditor may demand the guarantor to indemnify him against loss. This is a very unusual proceeding, and the interests of the guarantor can always be fully protected by the former proceeding. Section 227. Discharge of guarantors and sureties. Guarantors and sureties may be discharged in any one of the following three ways. 1. By a discharge of the principal, as anything which discharges the principal will discharge the guarantor or surety. 2. By the signature having been obtained by fraud. And 3. Lastly, by the surrender to the principal or other party to the paper of any collateral securities. Any alteration of the written instrument which will discharge the principal will also discharge the surety. The surety may be released by an alteration which does not release the principal debtor. In the case where a creditor receives from the principal debtor payment of interest in advance on a past due note, an agreement to give time is necessarily implied, and the creditor thereby debars himself in the meantime of suing on the note, and the surety is therefore discharged, unless the creditor can show mistake, or possibly an agreement that the right of suit should not be suspended. It is held by the weight of authority that the plea of fraud or misrepresentation will not avail to discharge a guarantor or surety as against a bona fide holder. The surety or guarantor is discharged if the holder surrenders any of the collateral securities to the principal or any other party to the paper. If the holder enters into a binding contract for the extension of time, they are discharged. Under the principle of subrogation, the guarantor or surety has a vested interest in the collateral security, which cannot be jeopardized or destroyed without his discharge from his liability. The agreement for an extension of the time of payment in order to be a discharge must not only be based upon a valuable executed consideration of some sort, but the agreement must be absolute and for an extension of payment for a definite period of time.